Good evening, everybody. We've decided to bring in, and it might appear to be a gimmick, but I can assure you it's not, Foska Muin, who's the brighter of the Muin siblings for tonight's little um, soiree, so to speak. And Foska's quite well versed in the COVID pandemic, particularly employment law. Struggles a little bit with commercial law matters such as leasing. We've got a few matters wrong in the last 12 months, so we'll defer to Mike for leasing, but Foska's going to be our go-to for the employment law side of things. But she got a really good email here. It's not from us at all. It's from a firm, very good employment for LHB, Langton Hudson Butcher. And so because it's COVID and lockdown, we're not really interested in and we're trying to expediently get as much information out as possible. I'm just going to sort of drip feed, read segments of this in terms of the advice that they have suggested for Auckland employers with regard to employment law, because I think it might not be pretty, so excuse me for having to look down and read like I'm doing some sort of third form school speech, but it's probably the most efficient way to get people out there what they want from this. So Auckland Alert Level 3 employers in Auckland should revisit their Alert Level 3 plans. I don't know about you, Michael. We don't have a plan per se. No. Check that they remain fit for purpose, update where necessary, and make them available again for staff. For employers in Auckland, the key rules at Level 3 are: 1, people must work from home unless then it is not possible and must stay home if they're sick. I would have thought that was self-explanatory. 2, workplaces can only open if they're providing essential service for workers, or workers cannot do their work from home. B, workplaces are, quote, operating safely, including that staff must be able to remain at least 1 metre apart at all times where practical. C, customers are not allowed on premises with exceptions for supermarkets, dairies, petrol stations, pharmacies, and permitted health services. And D, businesses can trade without physical contact with customers. This means bars, restaurants, and retail stores must close, but can run a contactless takeaway pickup service, including from inside malls. Hairdressers, beauty salons must all close, and gyms must all close. Employers are not permitted to open their workplace at Level 3, should comply with their obligations to their employees. Now, here's where it gets interesting. Who are also unable to work. Most of these will be informed by the employment agreements. Check these. If the employment agreement does not address the situations uncertain at this stage whether employers are legally required to pay these employees when they are unable to work. If considering no work, no pay as an option, legal advice should be sought. Workplaces that continue operating Level 3 must keep the health and safety standards front of mind, reintroducing rigorous hygiene regime measures, regular cleaning of common areas, physical distancing, contact tracing for all visitors, appropriate use of PPE, encouraging high-risk people to stay at home where possible, putting up physical barriers where necessary, and sending people home that have cold or flu symptoms. I wonder what a physical barrier would look like. Employers who are permitted to have employees attend the workplace during Level 3 must also consider whether it's safe to have everyone at work, so obviously some sort of balancing requirement there. Employees and contractors may travel into and out of a Level 3 area, for example, in this case, Auckland, for work, provided they do so for a permitted business or service. They do so directly and without otherwise stopping within the Level 3 area, and how they police that. And they carry proof of this in their work and home destinations. These businesses and services are limited and very specifically listed in the COVID-19 Public Health Response Alert Level Requirements Order 2021. I'll drop that into the comments, that link into the comments for anyone that wants to look to see whether they're included. These services include the justice sector, including the courts, postal and courier services, transport and freight services, emergency services, building and construction, services required for health and safety and key infrastructure, businesses engaged in the production, supply and packaging of and for food or drink. To ensure compliance, a schedule should be checked or legal advice sought. I mean, that's really just a rehash of everything that people by now would know. get legal advice. I think the one thing that really stuck out, to me there was the whole question of whether if employees can't work, can you not pay them? I would think, and I'm not an employment lawyer, and Michael, you are going to take over in a second and speak to that, but I would think that would be a fraught decision to proceed on that basis without particular specific advice from a lawyer about your particular situation. And even then, I would think a cautious approach should be preferred, particularly if there is no case law yet on it. I'm not actually aware of this area. Is there any case law, Mike, or what are your thoughts on that?
I mean, I'd have to say something equally vague. I don't know exactly what the deal would be there without reference to the law and to the relevant contract, but I would note that the Langton Hudson Butcher write-up that you were referring to notes that there are short-term absence payments as well that the government's providing. So there is support for businesses who are in a position where they have to pay employees who can't turn up to work because of sickness or because they're awaiting a test. So my first piece of advice would be to avail oneself of that and hope it doesn't come to those sort of tough decisions. But I would certainly take advice before going as far as to not pay employees that can't work.
100%. I think as well, patience needs to be stressed as well. I don't, admittedly, the intuition, and we were just talking before we came on air, Mike, the intuition is that it'll be longer than 3 days. Mm-hmm. The intuition was proved right the last couple of lockdowns. Having said that, you don't want to jump the gun and catastrophize everything far in advance of any actual announcement, or any announcement as to what is happening next, because you've just done a whole lot of mental gymnastics in your head, worst case scenario, catastrophize, and if it doesn't happen, you've just expended a whole lot of energy over nothing. So I would say the best approach is to be cautiously optimistic that we get out of this in 3 days. In that time, in terms of the employment law context, unless you've got a zillion employees, most businesses should be able to weather that for that 3 day period, even if it is undesirable or less than ideal. Shouldn't be catastrophic in terms of the financial effect. If, however, we go into another level 4 and extended level 3, businesses will need to turn their mind to what to do next. But having said that, I think I read yesterday that government had issued a decree or had issued a communication 7 days of level 3 or greater lockdown. They would actually be issuing another wage subsidy. So that would be, of course, some solace to anybody worried about the effects in terms of paying employees who were unable to work for an extended period.
Mm-hmm. I believe there's also going to be a one-off, what they've termed a resurgence support payment as well, that's characterised as being to provide cash flow for rent and wages. I think you need to show a 30% drop in revenue or forecasted revenue, and it's $1,500 per business and $400 per employee. So probably more helpful from a paying employee's perspective than from a rent relief perspective, given the amounts involved.
And when was that announced, Mike?
I'm not entirely sure. Sorry, Shane. I saw that today. I had a bit of a brief.
Yeah. And so, and when was that slated to be granted or actually put into place? On what events occurring or what duration of lockdown?
Once again, not without reference to the fact sheet, I couldn't tell you, but from memory, I think it would be similar to the wage subsidy, that it's like I recall reading, as you said, that that's slated to kick in after about longer than a week of lockdown. I imagine that this would be similar, given the forecasting elements, the drop in revenue required to be eligible.
Yes. Ah, God, like it was an interesting day at work today. Told the staff when we first got there, like, look, this is John Banks gave quite a rousing speech in that forum we did when we first met just over around a year ago, Mike. And like, it's what do you call it? The golden age of opportunity. It's it's a time where you can rest on your laurels and sit back and tell yourself that, oh, it's lockdown. There's nothing I can do. And it's COVID and people aren't at work and et cetera, et cetera. Ring your mate and your mate's like, oh, well, there's nothing we can do and this is shit. And blah, blah. And we've just had all the statutory holidays. We've just had quite a lot of disruption. We've had people really exhausted, including myself, coming off a really trying year, particularly from an emotional point of view. And I wasn't even really badly affected like some of my poor clients and some people I know closely. So to get through all of that, have a bit of a break, go through the stats, have some, nice time in the sun, batches if you're lucky enough to have a batch, or go away, and then get to this point and business just starting to hum again and pick up for a lot of us is quite dispiriting. But I said to our staff this morning, look, you've got to look at this like an opportunity, because the last couple of lockdowns for us proved to be laden with opportunity, maybe not per se in terms of the normal workflow that characterizes a services business such as ours, but a chance to work more on than in the business, and a chance to work on your skills and a chance to refresh yourself and attack things differently. And I know that after the first week of the first lockdown, where I had taken the other approach, the one I sort of issued this morning to my staff, saying, look, you can't go down that rabbit hole of anxiety, stress, anger, frustration, because it really won't get you anywhere. All it's just, you see these people making these sort of expletive laden rants on social, and it's like, I get the frustration and I've been there. Well, not with the rants, I've done all those internally, but I just don't think that there's any utility whatsoever. You've got to stay positive, got to use it as an opportunity. And I know there are people out there who are genuinely really badly affected by this, and my heart goes out to them, because that would be horrible. People like Brad Jacobs in his coffee club with a zillion leases and etc. He'll probably thinking right now, I don't know if he may or may not be watching tonight, thinking, God, this really sucks. Like, where are we looking down the barrel of all that gnarly, nasty negotiation with landlords, and some of those, horrific, obstinate landlords that would have caused, hell for people like Brad during the last lockdowns. Are they going to come out again? Have they softened their attitude at all? Has some sort of pragmatism have they taken heed of sort of a more pragmatic approach after being maybe battered into shape or worn down? Who knows? I mean, all those questions. It's like a Batman. Remember that Batman series from the 1960s that I used to rewatch as kids? It's, watch the space, come back for the same bat time, same bat channel every day. We're nervously looking at the government giving all of their directives, and it's just a great unknown, isn't it?
Mm-hmm. Yeah, I think obviously for some people, this will be more disruptive for others and come at a worse time than for others. I'm halfway through selling a house, so I'm watching with a certain amount of apprehension to see whether the lockdown becomes extended down the rest of the country. And I know that people that have any sort of business interest with a significant public-facing component of anyone that has to deal with commercial leases and the like, which is a lot of people, that there'll be all sorts of questions around that. But like you say, I mean, there's nothing any of us can do about the fact that it's happened. And sort of reviewed in historical context, there are generations and people that have had to put up with a lot worse. And I mean, I think that you just have to confront the circumstances that you're dealt with and try and make the best of them, really. And there is opportunity in everything.
Yeah.
So
what are you seeing in your practice For those of you who don't know, Mike's a civil litigator at the moment. What are you seeing that as trends in what you're doing at the moment? I can talk to it after you.
Yeah, last time, we saw an uptick in dispute type matters. A lot in that commercial lease space, but sort of things across the board. Just that everyone's sort of, I suppose, trying to. Sorry, my dog's just going off the chain back there.
He obviously took issue with, like we said, he's not a lease guy, is he?
No, more, and employment is the other area that triggered my recollection. Employment's the other area that obviously there was a lot of last time. Now it's obviously too early this time to really have seen a great effect, although even today I was close to closing an assignment of a commercial lease that I'd been working on over the last few days, and the incoming tenant is now trying to back out. They've realised that they might be taking on a premises they can't utilise for several weeks. So obviously, a loss of confidence and a certain amount of disruption is going to be the immediate effect, and then a lot more pressure.
What characterized many or most of the employment disputes during the last lockdowns?
Well, it was remarkably, it was very common that an employer would, they'd look at their business and they'd realise they were employing people who, it might have made sense in happier times to shift some of the load off the business owner. And this is mainly in the sort of SME category.
Yes.
And they realised that if they were going to streamline things, they could probably shift that work onto themselves or other employees and let that person go. But a lot of people, rather than running a proper redundancy process with all of the cost involved and the process involved, tried to come up with, I've seen quite a few very spurious reasons for dismissing people with cause. And so we did a lot of work around that.
Can you, without obviously naming any names, can you give us a light-hearted or perhaps humorous example of a spurious, as you call it, reason for getting without giving away the identity of the parties?
I'll try and think of I mean, I've heard probably sillier than this, but the first one that comes to mind is a woman who was dismissed on the basis that she received an email, a customer inquiry that was not particularly urgent, to her email address, work email address. She was working from home at the time, and she didn't respond to it until the afternoon the day later. So a sort of day elapsed before she responded to this email. There was no implication from that. Nothing happened.
Is she still in the country? Did she need a job? So that's a great time frame to respond. Yeah,
I know. I mean, I was astonished that anyone would consider that anything less than exemplary. But apparently that was reason enough. And so that was probably, most employers who tried this on got a bit more creative and came up with something a bit more plausible than that. Yeah. That was for a bit of backstory, as you know, Shane, speaking of opportunity, in the first lockdown in the year, when I and my colleague were just kind of getting our business off the ground and had the kick in the pants of the whole lockdown disrupting everything, we thought, well, how can we capitalize upon this? We worked out what areas of law would likely see some growth, and we set up a sort of satellite company dealing with just employment matters and set up
Unfairly fired. Give it a plug, Mike. Go on.
Well, I can't plug it, Shane, because at the moment it's operational.
It never was. It was the most woeful website. It was awesome. I love it. It was great.
It was very low rent, and I think that was, it's that sort of Chinese restaurant thing. Like, you kind of want, you don't want to go to a place that looks $1 million if you're looking for something cheap. Like, you want it to be, a little down a heel. And so anyway, this was our sort of somewhat mercenary attempt at being entrepreneurial, and and how we came to do quite a few of those sort of cases.
What was the site called? Unfairly Fired.
Unfairly Fired. There's it's not an original idea. There's 2 or 3 other such companies on the market with equally kind of disreputable sounding names.
It's brilliant. I love it.
We got a good amount of work out of it for a period, and helped a few people along the way. So yeah, no, it was a good little endeavor.
The whole question of leases, I don't want to go on and on ad nauseum, because it was just leases this and leases that in the last lockdown. But given we are lawyers and we know we have at least a skerrick of knowledge about the whole position under the leases, I thought we'd just quickly reiterate, if I can even remember, the key points. So clause 27.4 would allowed an abatement of rent. What was it, Michael? I can't remember.
27.6, and I think the phrase is fair proportion of rent and outgoings.
Fair proportion.
So there's a question about what that means. A lot of people have in the last lockdown sort of thought 50%. Meet in the middle has a certain intuition to it. What is interesting is that the one-off resurgence support payment notes that it's to provide cash flow for rent as well as wages. So how that interfaces with what is fair, if your tenant is receiving this payment that's ostensibly meant to cover rent. But as I noted earlier, given it's $1,500, that's only really going to be in play if the lockdown is of quite a short duration for most people.
I think it's 27.5. I said 27.4. You said 27.6. So
yeah,
if we split the difference, I think it's 27.5, isn't it?
I'm happy to go with that.
I think it was 27. I'm at 27.5. I think it was 27.5. God, it's amazing how you can have something in your head so much, and you and I both wrote articles about it, and you're so intensely debating the various merits of the ways to skin the cat, so to speak, in terms of how to calculate the almost incalculable. And then here we are a year or so later, and I can barely remember what clause it was. It just shows human beings, we have an extraordinary ability to overcomplicate and use too much brain rather than intuition and feel in these situations. And you just wonder how not to denigrate lawyers overly, because the public at large are good enough at doing that. We need to stick up for ourselves. But it's just it is an interesting point. You think about it, how intensely we can get into something like that and debate and kind of show our intellectual wares, and then a year later you can't remember what the clause is.
Well, relatedly, I just checked the clause. I can confirm, as you may have already checked, it is in fact 27.5.
Yeah, I did it. As you were talking, it came to me.
Which is a great lesson in hubris, because I was wrong. You were wrong first. If I hadn't thought to correct you, we could have both just let that slide, and no one else would have bloody cared.
No,
everyone would have been like, "Oh, that sounds about right."
Two shits. Somebody who does care, though, are the poor landlords and tenants who are left suffering, to the extent that if there is a further lockdown of long or medium term duration, we're no clearer to actually determining what that means. So all the ruffians and angle shooters from the last lockdown, or people who have, since fallen, how do I say, off the, I don't know quite how to explain that, but people have had a rough time of it, are perhaps willing to give it another shot in terms of going about things the wrong way or being obstinate. I don't know, like I wouldn't want to be in that situation if you've got one of the parties are being tricky, because we're no closer to actually sorting it out.
Yeah. Well, I actually looked, I mean, obviously the government's had a lot of time since all of this kicked off to give a great deal of thought and attention to how to make things run more smoothly should we go into another lockdown. And today, in anticipation of talking to you, Shane, I thought I'd go and refresh myself on what they've come up with.
It wouldn't have taken long.
The answer is very little. Basically, there have been some minor amendments to the Property Law Act. The only one that's likely to be of particular interest is that they've extended the working day period to kick someone out for default from 10 working days to 30 working days.
To 30, yes.
So that's occurred. And it's probably worth noting at this point for anyone watching.
I think the payment period it's extended from 10 to 30 as well, hasn't it?
Yeah. And on that, it's worth, for anyone watching who's on the landlord side of the fence, it's worth remembering that the payment period and the notice period don't have to be consecutive. They can run simultaneously. So you can provide notice on the day that that the default occurs, and those 30-day periods run at the same time. There are some people that are under the misapprehension that you have to wait for 30 days from the default to elapse before you can then put a notice in. So worth keeping in mind. But apart from that one, the only other thing that's been done to sort of innovate this is the commercial lease dispute service, which was set to end on the 31st of March. I suppose now they might extend it. But it's a subsidised system where people can apply for $6,000 for arbitration, for mediation, to have the subsidised process to determine these issues. The one snag is that it's voluntary. So both the landlord and the tenant have to agree to utilise the service before they can, which is hardly likely to happen. I wanted to ask you, Shane, I don't know a single person who's availed themselves of that. I wonder whether you do.
No, but I don't want to just lambast the government overly, because I don't have any real issue with them, and I certainly don't have an. I think it's like we talked about when we tried to write that. Well, we wrote those articles. It's like when you actually try and give it, a balanced or intellectual approach, and actually you try and bore into, or it's very, very, very challenging. So, but I still don't quite understand the efficacy of having a system where two warring parties, it would take a situation where the landlord and tenant are utterly warring to get into that position in the first place. I don't understand how it has any efficacy whatsoever to say, well, those warring parties must agree the service will be used. It's almost impossible.
Well,
if you liken it, sorry, just to what I got my train of thought for one of the only time I'm a bit out of shape tonight. It's been quite a long, not stressful, but like just enduring kind of day. Like just it's another change. I didn't sleep that well last night. It's just another upheaval and what's next, etc. But yeah, if you think about it logically, that it's the same as a clause in a shareholders agreement, or actually in the Auckland District Law Society deed of lease, where if the parties don't eventually agree who an arbitrator should be the arbitrator, an independent party such as NZLS will appoint that arbitrator. So they are forced to then go to arbitration. There's not an option to just say, well, actually, we're deadlocked out because we can't agree to use the service. I just don't see how the service could be. You wonder almost whether it was just to placate part of the business interests to say, oh, here's this idea. Well, if it can't be compelled to go into it, what's the point of having it?
I was going to say, I probably shouldn't be sardonic about the government either, because if I was consistent in my ideology, I wouldn't want them to do a single thing. I'd want them to just leave it up to privity of contract, free market, all of that. But in terms of the interventions that they have made with this stuff, I have a vague recollection. I may be wrong, but my recollection is that they did initially intend to have a much more toothy mandatory scheme for this stuff, and it was kiboshed by Winston Peters, I think.
That's right.
So
I think it was.
I think this is just an unfortunate creature of political circumstance. Expediency, I guess.
It's tough to know the real extent of the lack of action on that front compared to all of the other counterbalancing areas that they needed to put their resources. I remember once we did last year the talk about the apparent effort and attention that had gone into changes to the Residential Tenancies Act. You and I did one of these talks about it, and we talked about how it was perhaps not the most pressing matter to make changes to the Residential Tenancies Act. But again, that could have been, I'm sure it was, an election thing.
Yeah. No doubt.
But was it the best use of their brain power from that part of it? Was that their best use of their time then? Arguably not.
I mean, though, kind of riffing off that, when you initially said, there are more pressing things, it made me kind of reflect, in the last lockdown, when there was very little in the way of any kind of government intervention, support, or regulation around this whole leasing issue, most people that I represented in respect of those issues just sorted it out and got on with it. And for the vast majority of the commercial people in this country, the sky didn't fall in. That wasn't, or if it did, it wasn't because of the issues they had vis-a-vis their landlord or their tenant. And so maybe, the government was right to put its efforts and its money elsewhere.
I think, except for the most egregious of cases where people either didn't have that contractual right to relief under the 80 lease, so some of the more bespoke, big tenancies in the Westfield malls, etc., and people like we talked about, Brad Jacobs with his million leases all over the country, that would have been feeling the pinch as well, all the way up from the franchisees in terms of already tight margins. I think I largely do agree with that, but that's not based on any kind of quantitative, thorough, statistical. That's just an intuition.
Yeah,
the fact that it went away. The fact that it went away. I mean, did it go away because there was no long-term effect that wasn't somewhat papered over by all the money that the government's pumped into the economy via the subsidies, or did people just get, decide that there was no real utility in playing the violin strings and getting on with it? I don't know the answer to that. It's probably someone could, get pretty fired up and come on here and say, you guys don't know what you're talking about. This is what happened to my business. We had 21 leases. This is blah, 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 blah. And I'd be like, okay, well, who are we to argue with that? We haven't been that close to the coalface.
It's anecdotal, and, it wouldn't be to diminish, even if it is true, that there would be people for whom, it must have posed an enormous headache and, possibly been catastrophically difficult. Like, as you say, people who had a lease that didn't entitle them to any kind of rebate on the rent, or some of these people that have a lot of leases on their hands. Franchise is an interesting one. In fact, could you, you mentioned that for franchisees, that it was particularly difficult. I just had a couple of sort of lease-related things recently with franchise businesses. I'd be interested to hear more about that.
Well, if you're a franchisee, if quite often with a franchisee, you're in an institutional tenancy, say a mall.
Mhm.
I'm talking about really hospitality sector franchises. So quite often you'll have a bespoke lease, which a big law firm has drafted, which won't have clause 27.5 or any equivalent wording. So there is just carte blanche. There's no actual entitlement, and because there's no statutory entitlement to such relief, it's a creature of the contract. Of course, the franchisee can be, who is already in a relatively powerless position, can be lent on just to pay the full rent, right? Or they lose the $300 to $500 to $1 million key money they put in to either start the business or buy the existing business at a multiple. Furthermore, often cagey and well-travelled, I should say, I'll describe institutional landlords will require excellent security from either the franchise or behind the franchisee's personal guarantees and or significant bank bonds. So that's where just explain to our viewers, that's where the bank, your bank, so if I'm a franchisee, I go to my landlord and he says, we don't trust that if there's a default under the lease that we'll be able to recover enough of our costs within, say, 6 months of you leaving. So we want $50,000 or $100,000 of the equivalent of, say, 3 to 6 to 9 to 12 months rent, a figure equivalent to that much rent plus OPEX GST in your bank account, and your bank makes an irrevocable undertaking to us that without having to ask you first, as in ask the franchisee / tenant first, they're going to take that money if there's a problem. Now, you can start to see, if you join the dots there, you can start to see that if you're an institutional landlord, despite public shaming, naming shaming, and some of the stuff that happened, I think it was down in the Civic Theatre around there, that area, with some of the landlord around there who'd sound like a real nasty piece of work, just giving absolutely not a quarter to anyone. It sounds like some of these institutional landlords played that game with franchisees, and either real good bugger franchisors had to come to the party, or these people had to scurry to literally stay financially above water. So that's a difficult situation to be in for a franchisee. And that was all just hypothetical, sort of like you, to use your word, riffing along about the conglomeration or aggregation of circumstances that can compound together to put people really up against the wall. That is a reasonably well-flowing example of some of the things that can happen to these people.
No, that's very interesting. Sort of like more broadly as a kind of hypothetical of how all these things can come together. But like the reason I was interested is just that one of the matters I've been dealing with recently involves a business that was a franchisee who, over the course of this year, various things, probably quite lockdown related, have caused them to have to basically exit the business, and the franchisor wants to assume the lease. And I don't have a lot of experience with franchisees, so I know that's an area of particular expertise for you, Shane. So sort of understanding some of those background mechanics was, quite interesting.
When you're in that sort of position, the job that the lawyer acting for both the franchisor, the franchisee / tenant, sometimes a franchisor can be the sub-landlord, and the landlord really comes to the fore. We had a situation years ago, acting for a client who's now a business partner of mine. The story is well known amongst our little community in Auckland, whereby he bought a business and very quickly found out that certain things had happened in the business and wanted to get out. One of the complicating factors, I will say, was that he had entered into a lease whereby he would be stuck with if he purported to terminate the agreement for sale and purchase for the sale of the business. So he would be stuck with this lease if it turned out. But this is where it gets real interesting. Well, for us law nerds anyway. First of all, you can make, and we do sometimes make, the deed of assignment of lease conditional upon the underlying business sale proceeding. So you can have your landlord committed, the assigner committed, and you're only committed to the extent that you can complete the actual purchase of the business. Because what good is a lease without the business to be able to run it from, if it's, say, a franchise business and you don't have that license to run that business? What good's a $200,000 a year lease to run some sort of huge, I don't know, going back, Payless Plastics or some huge retailer or distributor if you don't have the license to actually use? So that can be a trap for young players. But what happened in this case is we got the lease, and it was one of these situations where the landlord had contracted directly with the franchisee, and there was no contractual right of the franchisor, who had been really poorly drafted. There was no contractual right of the franchisor to take over the lease if the franchisee/tenant terminated it. There was a right. There was a right for the franchisor to take over the lease if it terminated it, because the franchise agreement was in default. But we got in first, and we terminated the franchise agreement. Franchisor's lawyers turn around and say, "You've got to give us the lease because we've terminated." We said, "No. We've terminated, and there was only a right in the lease for the franchisor to assume the lease if they." So they went to the landlord and said, "We've terminated. We've kicked them out. We're taking over the business." And the landlord didn't like the franchisor and said, "No, you're not. We've been dealing with the tenant and his lawyer, and we're quite happy with dealing with them, and we're not going to deal with you at all." So what the franchisor in that situation needs is some sort of separate deed or tripartite deed where they are bound in that deed to actually be able to assume, the franchisor is able to compel the landlord to assign the lease, the tenant's interest in the lease, to the franchisor in an unfettered way on the occurrence of certain default events under either both the lease and the franchise agreement. And there's a bit of care and skill that needs to go into that. But it's you'll never get it. It's just luck sometimes, because in some situations, the last thing in the world that the franchisor wants is to be on the hook for the lease. If the business fails, then it has a liability and a bank guarantee to support. So sometimes they're actually happier to go, "Well, don't look at us, it's not our lease." Whereas other times they're desperate to try and take it back over because there's a good EBITDA in the business. They want to take it back and hock it. So I've seen it done every which way, and sometimes it doesn't fall on all fours with what any party in the mix wants to do. Sometimes the landlord would rather not, that the franchisor doesn't have a right to assume the lease, because they just want to get rid of all these turkeys if they're a bunch of shit kickers, and they want to take the thing over and give it and sell it on the open market. So it's a kind of never-ending palaver in those situations, and everyone's sort of running for cover, trying to get away from liability for the documents they've drafted, going, "It wasn't me."
That certainly sounds like my first experience, a real palaver, much more complicated than things would usually be. I had kind of the inverse situation where the franchisee and the franchisor executed a sale and purchase agreement in respect of the business, and the franchisor moved into the premises and assumed trading before they had even approached the landlord to discuss assignment of the lease. And then the franchisee said, well, the landlord said, "We'll only do this, on various terms that involved making good payment of arrears and the like." And the franchisee attempted to refuse, to which, my position was basically, "Okay, well, fair enough, but you explain to your franchisor, how that's going to affect the S&P they've signed with you, and the various payments they've made on your behalf." But no, just a real nightmare of a thing.
I'm trying to rack my brain. We had another situation. Oh God, this is a good one. Since we're telling, we'll probably wrap it up after this, but we had a situation. It didn't end very well for me actually. It was a shambles. So I had a situation, but I had a good learning in it. It was an expensive learning, but a good learning. So I had a situation where we acted for a franchisee. They were insistent on taking over the lease, even though the vendor of this franchise business wouldn't give us a lease because, quote, the landlord was about to sign a new lease. So we went back and we said, well, and I'd never do this again, we went back and said, we'll accept that if you confirm your client will enter into a lease on the same terms, including but not limited to the same floor area and same annual rent for the remainder of the current term. The guy came back and said, yes, we will grant a new lease, but he never said, this is the other lawyer, he never said we will grant a new lease. I went back again and I said, please confirm that the floor rent and blah. Then I got busy because I was in the middle of that other shambles I told you about for my client with the franchise. So then I went back. I never went back and said, yeah, I proceeded on. What happened was the client was useless. And what they did was they never got the new lease signed. By the time that they were going to get it signed, the gym that they were trading out of took off big time, and the gym owner, the franchisor, the gym owner, the sublessor, tried to reduce the floor area of this franchise business considerably. And they relied on the fact that there was no lease in place because the lease was expiring. There's no lease in place to actually squeeze this, so there's nothing we could do. So then the franchisee obviously got into financial trouble. So their lender got involved because it was worried about its security and lent on me and kind of tried to bully us around to say it's your fault because we didn't accept him a lease. And I felt incredibly indignant about the whole thing because I'd been the one for like 6 weeks saying this is a really stupid idea, don't do it. And I got so sick of it, I just said, you know what, here's your freaking lease. Off. Anyway, long story short, the client had the temerity to join up with the bank's lawyer and then try and threaten to go to the law society about me because I hadn't got a lease. And in the end, they wanted $5,000 or $6,000 for fees. In the end, I fucking have had a few law society complaints. Never actually for anything to do with my work, but just for being a bit naughty, which everyone knows about. So I don't have to tip on any. I don't have to really watch my P's and Q's about that. But I thought, the last thing I need. It wasn't long after I'd been in trouble, and I said, the last thing I need is the law society having. And at the time, I was probably a little bit conservative. I was looking back, I had nothing to worry about. I did my best, and I actually did everything I could to get a good contractual position for the client. But looking back, I was probably a little bit worrisome, anxious. I don't want any more trouble. You know, that's what happens when you get in big trouble. You're like, anything looks like trouble. So I ended up giving them the money back and saying, look, here's your money back. I wasn't very happy about it, but it was a salutary lesson because it made me realize that while at the time everyone's your mate when they want things done quickly, and I actually had a situation today on a very big contract for a client where he was so eager after being mucked around on another deal, he was so eager to pen these new agreements that he said, him and the broker were like, just sign the stuff. We're not worried. We really want to get this deal. It turned out that these clauses had protections for the purchaser. I was acting for the vendor, which were quite expensive and vague, that gave them protection for some of the very issues that we had 2 deals ago for this same client with a similar situation. So I said to my client, hey, Mr. X, look, these warranties will put you in a position, if we have any of these issues again, you're going to be liable after settlement for an uncapped amount. So I know you really want me to act expediently. I know you really want the deal done. And I know, we're mates and we banter every second day. But as night follows day, if you sign this again and I don't advise you on it, you're either going to turn on me and say I've now got a $100,000 or $200,000 claim, for some compliance issue after these businesses are sold.
Mm-hmm.
Or you might not go that way. You might be decent and say, yes, Shane, I acknowledge you told me not to rush in there, but you're still going to be facing this problem. And but for me spending an hour and a half of my time going through all this and giving proper advice, I'll do it as quickly as I can. But let's try and balance the two here. So you've got to make sure that you are expedient to get the deal done commercially, so you're all hands to the pump. But you've also got to cover your client, because otherwise, what's the point for our existence at all? Might as well just sign it yourself.
I mean, that psychology is powerful too. Like, if someone really wants to get a deal through, the last thing you want is to find some sort of little snag somewhere in the contract that your lawyer says is potentially bad news, may or may not be, and know that you have to go down the path of litigating that, especially if the other side's kind of coming at it like, all very friendly. Oh, come on, let's finish this. It's very tempting to just sort of throw caution to the wind on that kind of thing.
When clients particularly, it seems to always be young shareholders in their first venture, and you're trying to convince them to pony up some dough for a shareholders agreement, saying this is the commercial matrimonial, will be the most expensive yet valuable document you ever signed. And a common one I get is, she'll be, it's all good, mate. And I say, look, I've got a saying about that. It's all good until it isn't. When it isn't, by gosh, it's not good. it's the pits. And these guys who are so harmonious and so in sync with each other and really excited and didn't even turn so much of a speck of attention towards the potential downside, all of a sudden want to kill each other over the most supposedly minor thing that the other's done. So, it's very much, I sum up our conversation tonight, and which has kind of weaved its way into the situation, which in a way doesn't have a lot to do with COVID, but it's just really a good discussion for people watching to understand a little bit more about what makes lawyers tick, and the sort of balancing act that we have to do is do get good advice. And if you're going to act expediently and you want to get a deal done, which commercial people want to do, I deal with them every day, that's what they want to do. And to be honest, commerce depends on it. It has to be done quickly. Do, however, still listen to your lawyer's advice, so at least you're making any decision to either not follow the advice or to somewhat dismiss the advice. At least you're doing that on an informed basis, so you're actually aware of where things can go south. Because for some of us, me included, it actually takes a bitter hiding or loss on the back of not listening to advice that actually makes it really stick. So the next time that you're confronted with that same situation, you think, man, there was a lot of pain involved with that. Last time I didn't listen to, Mike Moen told me this will happen if I do this. I went and put my hand on the stove and it all happened. And that's why the best guys in business, they are tough and ruthless and they're very quick to act, but they are able to pause and take a breath and actually do a risk, cost benefit calculus on the way through. And it's a very, very important step if you're going to be successful in business.
Oh, I think that was a very good place to wrap up, Shane.
I think it was, and I forget the name of the dog. Where's the dog gone?
I'll bring him back up for a moment.
Fosker's going to wrap us up. He's got an announcement to make. Fosker doesn't think that we're going to level 4. He thinks everybody needs to take a chill pill. Do send out all your invoices, though. Make sure you get all your invoices out and chase those invoices. I got about 3 reminders today, which was great. So I said to my staff, look at all these invoices coming in. All of a sudden, people want to be paid in a hurry. So you know what we're going to do? And they said, pay them. I said, absolutely not. You go out there, you find as many of our invoices that haven't been paid, and you chase these bastards up. All right, mate.
Yeah, very good. Good. Pity we can't catch up probably this week, but hopefully do this again soon. Maybe next week if we're not. In another
lifetime, Mike.
Yeah. Great.
And
thanks,
Fosker.
Shane.
Cheers, Fosker. See you, Mike.
See ya.
Hey, mate.